It was a record sitting of the Constitutional Court, 3 days to hear an application for leave to appeal by the Competition Commission over the alleged collusion by banks to manipulate the rand-dollar exchange rate. Hello and welcome. My name is Zoleka, Qodashe, and we'll be looking at the landmark hearing before the Apex Court. It's been 10 years since the Competition Commission attempted to take action against more than a dozen local and foreign banks for allegedly colluding to manipulate the rand-dollar exchange rate. It's alleged that between 2007 and 2013, 28 banks or traders would log on to instant messaging platforms where they shared sensitive information and, in many instances, secretly with their competitors. The Commission accused the banks of making arrangements to assist each other and would regularly agree on a bid-offer price for the buying or selling of the rand-dollar pair.
It's quite remarkable that this was able to happen, and practically all that really happened here is that a bunch of independent banks came onto a instant messaging service on Bloomberg's terminal and, well, allegedly started saying what price they wanted for the rand dollar, which is not at all the way it should work. In a perfect competition society, what should happen is each bank should independently say what price they're going to give. And as a result, the consumer gets to decide between a number of banks which bank to use when sending money into or out of the country. But here you have every bank talking to each other and really fixing the prices. And so this is something that absolutely shouldn't have happened. And it will be quite a knock for the banks if they are proven to have been guilty in doing this in the years 2007 to 2013.
It was in 2015 when the Commission caught wind of the alleged conduct and accused the financial institutions of being in contravention of Section 4, subsection 1b of the Competition Act. The regulatory authority says based on the behavior of the banks, the inference that can be drawn is that there was a single overarching conspiracy, or SOC, and referred the matter to the Competition Tribunal in February 2017. The tribunal agreed with the Commission that it had jurisdiction over foreign banks with a footprint in South Africa. Upon appeal before the Competition Appeal Court, the Appellate Court ruled in favor of some banks, finding that the Commission failed to establish jurisdiction. This was a point that was emphasized by the respondents before the Constitutional Court.
The court ordered, consequent upon a finding that personal jurisdiction was required in the particular form which the court adopted, and that consequence was that the new referral affidavit must be in addition in the case of all the named respondents set out on the facts on which the Commission relies to allege that there are adequate connecting factors between the parties and the jurisdiction of the Competition Tribunal sufficient to establish personal jurisdiction against all the named respondents.
But this was not a submission without challenge.
Now, that is somewhat different to the fixed test as formulated by a number of jurisdictions. The United States, the European Union, Brazil, Nigeria. As those countries have all accepted that in the context of competition law, some degree of extraterritoriality is necessary to properly address and combat anti-competitive behavior in that industry. Now, is the submission that's being advanced on behalf of the respondents that you represent not an outdated approach to jurisdiction and potentially harmful for the South African market?
Common law dictates that jurisdiction is established when parties or entities are based in the country. But Section 3, subsection 1 of the Competition Act stipulates that the statute applies to all economic activity within or having an effect within South Africa.
We submit that there is no reason from the structure of the Act to constrain its effect by importing the common law. The Competition Act, in a sense, is a statutory delict. It's an invention of the statute. to address economic activity. It's one of the few statutes that address market power. Most of the statutes we have are addressing political power. This is one of the few that is specifically designed for market power. And it knows that the markets do not respect geographies. And therefore, because the markets do not respect geographies, the legal instrument needs to match the scope of market activity. And matching the scope of market activity means do not constrain the effect of the law to the geographic boundaries. So, two people sitting in Botswana can manipulate a price of a product that is sold in South Africa. And because there is nothing to connect them to South Africa according to the CAC, we would never be able to prohibit or stop the conduct at all. Another firm could conspire in South Africa. Before they get prosecuted, they leave. And then again, our instruments are blunt. They cannot do anything about them.
Failure to establish jurisdiction could deal a deadly blow to the Commission's application.
The issue here is that you have foreign banks that were trading using rand, which are arguing that we cannot prosecute them because they are not South African. So they said we don't have powers to prosecute them simply because they are not based here, irrespective of the fact that they were using the South African rand to collude, and the effects of that collusion had an effect on the South African economy. So we are disagreeing with that strongly, so that for as long as it involves the rand, and for as long as it has the effects in the South African economy, the South African Competition Commission has the jurisdiction to prosecute any conduct that has an effect to the South African economy.
The banks argue that the Commission seeks to revive the same arguments on the same merits with the same parties in a matter that the Competition Appeal Court has already ruled on, and importantly, which the Commission did not appeal. The legal doctrine prevents litigants from re-litigating a matter which has already reached finality in a different court.
The reality was the Commission was prepared to be bound by those orders in keeping with the res judicata and issue estoppel principles and to attempt to comply with them as it evidently thought it could do. The Commission cannot now attempt to reverse course and advance the kind of arguments which would have been competent in an appeal against CSE 1 in the context of an appeal against CSE 2.
This was an issue that the justices of the Apex Court also grappled with and pressed the Commission on.
If it is res judicata, the whole point of res judicata is to take it off the table, to mean we shouldn't decide it. We can't decide it in this case. Now, I accept, of course, that this court can, when a judgment of the Competition Appeal Court is quoted to us as a precedent in relation to a matter that is properly before us, we can overrule any CAC judgment and say it was wrong. But it first has to be germane to an issue it is proper for us to decide. And to decide whether your Section 3(1) argument is right or wrong, is properly before us, we must first decide whether it is res judicata. At most, if we found it was res judicata and that there weren't grounds for departing from res judicata, we might say we leave open the question whether CAC 1 was right in this respect.
The regulator's application was also challenged on evidentiary grounds. After the first order of the appeal court, which directed the Commission to draft a new referral, it added Nedbank without a joinder, the process of consolidating the applications. The Commission accused Standard Bank and ABSA of withholding quotes to help Nedbank fix the exchange rate. The banks again opposed this on grounds including that there was insufficient evidence to support the conclusion that there was a conspiracy.
Now, with respect, Justices, I think it's been pointed out before that the 1st of January was a public holiday. The time period indicated, which is starting at 2014 UTC, you have to add 2 hours in order to get to South African time, So we're talking at 10:15 on a public holiday, after normal business hours, and more particularly on New Year's Day, Absa and Standard Bank are accused of withholding quotes. Now, the Competition Appeal Court had a fundamental difficulty with this notion. And the proposition was put and not properly answered, we respectfully submit, well, why do you expect Absa and Standard Bank to be sitting in their offices duly posting quotes at that point in time? It's a public holiday. They're no doubt sleeping off the festivities of the night before.
Standard Bank also argued that it reached out to the Commission for engagements after it found no wrongdoing on its part, but to no avail. In 2024, after the Commission was given an opportunity to draft a new referral, the banks again took the watchdog to task and headed to the appellate court. The appeals of most of the banks were upheld. It found that the mere involvement of the Rand in the alleged conduct did not constitute a connecting factor to establish personal jurisdiction. Also important, the CAC found that the Commission's referral to the tribunal did not include the plausible evidence to demonstrate each individual bank's participation in the alleged conspiracy.
Part of the case that the Competition Commission would be making is that although it's got powers to investigate, to some degree, when you're dealing with foreign companies, you are limited in being able to access all the information. So you require the tribunal process to surface some of that information in the way that the case is pled in the requirements for discovery in response to their pleadings. So what's being objected to at the moment is that there was not sufficient evidence to connect these companies to an overarching conspiracy. And the Competition Appeal Court was allowed to make a determination on what was going on in the tribunal case.
However, when the matter returned to the Competition Appeal Court last year, the court found in favour of the Commission in respect of 4 banks. This was not the only application before the Apex Court. There were 2 others in which the Commission was a respondent and another one seeking to cross-appeal. We'll unpack this in part 2. Stay with us. Thanks for staying with us. Let's take a look at the cross-application by HBEU, which is a subsidiary of British-registered HSBC. HBEU is a partly foreign bank as it has a presence in the Republic. Thus, the jurisdiction of the Commission was engaged. In its referral, the regulator cited a Mr. Christopher Hatton, who was in the employ of HSBC and, according to counsel, not HBEU. The Commission argued that Hatton, a trader, was implicated in a number of chats. The bank then filed a dismissal application, but the order of the Competition Appeal Court found that an inference could be made that Hatton was also acting as an agent for the European entity, but the bank charged that the Commission had the wrong guy.
The allegation is made that there was authority on behalf of the relevant traders, but there's simply no proof in that regard. The Commission's allegation is simply a cut and paste of the averment that they put up in the case of the other banks. The third submission I want to make is, in competition proceedings, it's not sufficient to plead legal conclusions as it would be in action proceedings. So in action proceedings, you can get away with drafting a very skeletal set of particulars of claim. But the whole point of Rule 15.2 of the tribunal rules is to say that there's a burden, I don't mean it in a legal sense, but there's a burden on the Commission to substantiate the averments and to plead the material facts. So it was therefore incumbent on the Commission to tell us what is the factual basis for the averment that they rely on to say that Mr. Hatton had authority to bind HBEU, and there's simply nothing there.
Cockrell accused the Commission of being in violation of the Tribunal's rules as set out in Section 15, subsection 2, which prescribes that a complaint referral must be accompanied by an affidavit setting out the material facts or the points of law relevant to the complaint and relied upon by the Commission. But the Commission's lawyers hit back.
The actual pleading in relation to HSBC, which is the United Kingdom entity, explains the basis for drawing the inference that they were duly authorized. And that is at page 472. So it's actually not a bold averment. So it's 471 from paragraph 303 and 472 at 304 and 305. It says in 305, the 14th and 19th respondents are members of the same group of companies and are therefore directly or indirectly linked to one another. Now one can say, I don't like that way of attributing authority, but one can never argue that authority is not factually pleaded. What is the basis for inferring authority?
Another bank that brought action against the Commission was US company Credit Suisse. The bank was one of the few that lost its application before the Competition Appeal Court. The bank applied for leave to appeal before the Apex Court, arguing that it should have also been treated as a purely foreign company and not only in part, and therefore that the competition authorities in South Africa had no jurisdiction over it. Counsel for the bank stressed that the Commission had not established a link between the entity and South Africa, also a determining factor for jurisdiction.
In respect of the foreign peregrini, the appeal court held that personal jurisdiction must be established in accordance with the connecting factors test. Now, when this matter reached the appeal court in the second round, the appeal court considered whether the Commission, on the new case now pleaded in its amended referral, had pleaded sufficient facts to satisfy the connecting factors test. It held that in the case of foreign peregrini not alleged to have been part of a conspiracy in which they participated with South African banks directly, the Commission had failed to plead sufficient connecting factors.
But Advocate Nlugai Toby argued that this was a misinterpretation of the law. He submitted that the bank was added because it was on the same instant messaging platform at the time of the alleged collusion.
That distortion of the law assumes that the way to establish connecting factors is to find foreign banks in individual communication with local traders, which is not the law. The law is, we've discussed already. So when you apply the correct legal standard, the inevitable outcome is that Standard Securities is Credit Suisse Securities was correctly added, and there's jurisdiction over them.
The last appeal to be heard was that of BNP Paribas, also one of the banks that was dealt a blow by the Competition Appeal Court. But the bank believes the court misunderstood its pleadings. Now, before the Apex Court, the bank argued that the Commission provided contradictory allegations to the tribunal.
The Commission alleges that the conspiracy continued to operate using different modes of communication after September 2013, alternatively, after the implicated chat rooms were closed, further alternatively, after the respondents' traders no longer had access to the Bloomberg electronic messaging system. And I want to make it plain that we have no difficulty with the alternatives. It's the entire submission there. And the fifth is that the Commission does not know the date on which the overarching conspiracy between the respondent banks ceased to operate. That's similar to the third. But then they add another phrase, if it has indeed ceased to operate. So they leave that open. Now, Deputy Chief Justice, the test, of course, in exception, is that we must accept that every allegation made in the referral is true and correct. That's the basis on which we judge the exception. So it is both true that the Commission does not know the date on which the single overarching conspiracy between the respondent banks ceased, and it is also true that it continued only until September 2013. And I have to ask the question as to why, if you don't know the date on which the overarching conspiracy ceased, then on what basis are you pleading that it lasted until at least September 2013?
Campbell argues that you cannot not know something and know it at the same time. But the Commission submits that this is a baseless claim. It submits that the date provided was simply the minimum.
Cartels have evolved. They are now bigger, complex, and transnational. And this case is a classical example of a transnational cartel. Not only do the cartels not respect territorial borders or nationalities, they also do not respect any product in pursuit of profits. The courts would have read many cases of cartels. People are fixing the price of the selling of oranges or the selling of bananas, many judgments like that in the European Court of Justice. But here what we have is something unique, which is that they targeted the sign of our sovereignty, which is the rand, in a perverse scheme driven by profit motives.
But what were the effects of such alleged conduct?
If everyone's having to pay more than they should because banks are coming together and say we want everyone to pay this price rather than letting the market work its magic, you have a situation where everyone's paying more for imports, more for exports, more for investment, and it does two things. Number one, to the everyday person, it increases the price of goods in the shop because we have to import some of those goods, and that import cost is a bit higher, which in turn results in higher prices. But number two, what it does is it reduces our GDP and our growth.
The Commission's application must, among others, satisfy the test for leave to appeal. This means that there must be prospects of success and that there must be compelling reasons that another court may come to a different conclusion. So what are the prospects of success in the matter before the highest court in the land?
Very difficult. So I went through the 45 affidavits that have been put together by the Competition Commission and the banks, and it does seem that there is indeed a reality that the Competition Commission, in framing its case, was given multiple bites at the cherry. So even at the lower levels, at the Competition Tribunal phase, they were told that, look, we hear what you're trying to allege, but the case that you're putting together is not cogent. So they were actually given, I think, 3 opportunities to actually put together a case. And even after multiple opportunities, that level of jurisdiction said, well, of evaluation said, actually, you don't have a winnable case here. So the Competition Commission has lost on the basis that the way they've decided to package the case under the idea of a single overarching conspiracy is, for me, the fatal flaw in that. But of course, there's also the banks that have said that we don't even need to entertain what it is that you're alleging against us. You simply have no jurisdiction.
The sticking issue will be, among others, whether the competition authorities in South Africa can exercise jurisdiction over purely foreign and partly foreign companies, and whether the Commission's application is properly before the court, or if it's a violation of the res judicata principle. Depending on which way the judgment goes, the Apex Court could send the matter back to the tribunal to continue if it sets aside the order of the Competition Appeal Court and allow the banks to defend themselves before the tribunal. I'm Zoleka Qodashe, and thanks for watching.